Hi, it's Mike DelSignore, Massachusetts criminal defense attorney. In today's video, I want to talk about what happens if you have a Rhode Island license and you're charged with OUI in Massachusetts. I handle a lot of cases in the border areas, a lot of cases out of Attleboro, Uxbridge District Court, where my clients have Rhode Island licenses, but it can happen really anywhere in the Commonwealth. So what's the difference when you have a Rhode Island license? Let's say your client refuses a breath test and they're stopped 95, arrested, brought to the Attleboro District Court. So initially, their license is only going to be suspended in Massachusetts. It'll be suspended for 6 months. But Rhode Island, when they find out about this, the suspension, can suspend for 6 months. So here's the decision that you need to make. If it's a penalty for the client to not drive in Massachusetts, then you might want to report it to Rhode Island so they have the two suspensions at the same time. For some of our clients, maybe they never need to drive in Massachusetts. Maybe they say, you know what, I'm going to keep my license as long as I can. When Rhode Island catches up to me, I'll then serve that suspension. So you want to make sure your client is aware that a suspension may be coming down the road in Rhode Island. And then you can report it through, there's a suspension division. You can give Rhode Island notice, and then they'll give credit for the suspension concurrent with Massachusetts. If they don't find out, let's say you plead the case out in 3 months. Your client gets a continuance without a finding, 45-day license loss. They think they're almost through the 6 months. Then Rhode Island says, no, we just found out about this. So the 6 months for us starts on the date of the plea. So that's that's basically the major license issue you need to address and need to understand if you're charged with OUI. And you have a Rhode Island license. The case, though, essentially is the same. You know, you might want to fight the case. You know, if you refuse a breath test, they don't have the evidence against you. It's a subjective case. So in Massachusetts, in courts like Attleboro, Uxbridge, you're generally not going to be punished for going to trial. If you're found guilty, typically you get pretty much the same resolution. Rhode Island's the suspension isn't going to change whether it's a guilty or quaff. The suspension will be the same. So you might want to consider taking this case to trial. Now, things like field sobriety tests, like the 9-step walk and turn, one-leg stand, those tests are difficult to do for some people that don't have any alcohol. There's a lot of reasons other than alcohol why somebody can't balance on one leg. Somebody might have a medical condition that prevents them from doing the 9-step or the one-leg stand. What I ask officers a lot of times on cross-examination, the assumption is, so what happens when you're out on the side of the road, cars were whizzing by, and you were given these set of instructions. The assumption is that if you didn't have any alcohol, then you would get the instructions immediately first time, and you'd do flawless on the test. And we know from common sense and experience, people learn and pick up things at different speeds. So sometimes somebody may not pick up the instructions as fast as someone else. You might have to tell somebody something 2-3 times before they're going to understand the nuances of some instructions. Now, these aren't complicated instructions, but still, the officers spend at least a week on these tests. They have a manual. Some of them will actually read the instructions from a card, which I think certainly undermines the claim that these are easy tests, that you should be able to do them from memory. If you took a breath test and were over the limit, then your license will be suspended in Massachusetts for 30 days. Rhode Island typically doesn't pick up on this suspension, so as a practical matter, then if you resolve the case, you'll be looking at between a 90 and a 6-month license loss. Typically, if there's a breath test, I think most of the time the Rhode Island registry will give you the 3-month license loss. If there's a refusal, it's going to be 6 months. They can suspend for 3 months for the DUI and 6 months for the refusal. However, generally they'll run those concurrent. So I haven't seen anyone get a 9-month suspension. So generally you're looking at 3 months for the DUI, 6 months for the refusal, if you have a Rhode Island license. That's a first offense. If it's a second offense, then generally what's going to happen is the Massachusetts suspension is generally going to be much longer than the Rhode Island suspension, and you're going to have to get reinstated in Massachusetts, and then you'll get reinstated in Rhode Island. But for today's video, I'm just going to talk about first offense OUI cases. So if you, and keep in mind too, many people assume you can't win a case if there's a breath test. Don't assume that. Breath test evidence can be inaccurate, unreliable. There's ways to get it excluded from evidence. Make sure the lawyer you speak to understands the defenses and how to keep a breath test out of evidence. I handle these cases every day. It's my passion to help people charged with OUI cases. I appear in Attleboro, Uxbridge Court, and courts throughout Massachusetts every day. I'll be glad to help you explain the license consequences in not only Massachusetts, but whatever your home state is. I get people with Michigan license, New York, Connecticut, New Hampshire. I've pretty much seen all the states, and if I don't have direct experience with that state, I have contacts throughout the country, DUI lawyers that I know from attending national conferences that I can check in and let you know what you can expect in your home state. So if you need any help with an OUI case, call, text anytime, 781-686-5924. Mike DelSignore, I'm here to help you make the best decision possible on how to handle your OUI charge.